10:02. I'm Robin Kauser. I'm the presiding officer for the Dyslexia Therapist and Practitioners Advisory Committee. And I would like to start this meeting off with calling roll. Misty Dempsey. Okay. Helen Masick. Here. Latricia Niagos. Here. And Betty Daniels. Here. Okay, that's great. I certify that we have a quorum present. And we'll go through some quick introductions. If we just want to start with you, Helen.
Okay. My name is Helen Masick, and I am an educational diagnostician, and I do testing for learning disabilities, including dyslexia.
And where are you from, Helen?
I'm from Hutchins, which is just south of Dallas.
I'm Latricia Nigos. I'm the community member of the board, and I'm from Amarillo, Texas.
I'm Robin Kauser. I am the presiding officer. I'm a licensed dyslexia therapist, and I have a private practice in Fredericksburg, Texas.
Hi, I'm Betty Daniels. I'm from Brownsville, Texas. I work in the Dyslexia 504 department, and I am also a certified academic language therapist.
Okay, thank you. And do we have any introductions that we want to make over here with our staff members that are here?
We can do that.
Sure. Nick Boinas, Chief of Staff.
Mary Winson, Attorney, Advisory Boards, Office of Strategic Communications.
Laura Pefferly, General Counsel's Office.
Okay.
Good morning, I'm Tamala Fletcher. I'm sitting in for Delia Luna.
Okay, thank you, Tamara. Okay, I believe that we all got copies of the minutes, and has everybody had a chance to review those? Were there any changes that needed to be made to the minutes?
No.
Okay, if there are no further corrections, then the minutes will be approved. Yes.
I move that we accept the minutes as presented.
I'll second that, Helen.
Okay, then we'll move that the minutes be approved. Okay, the next item on our agenda is for public comment. I would like to remind everybody that we are being videotaped and recorded. If you could please turn your cell phones off. And if you are here to make public comment, there are cards over here on this table to be filled out, and you can turn those cards in over to Tamala, and we'll be sure and call you up. Is there anyone here to make a public comment? Okey-doke. Okay, so we'll move to item E on the agenda, and these are the staff reports, and we'll start with the executive office.
Madam Chair, board members, I'm Nick Boinas, TDLR, and here to present the executive office report. As you remember from the last time we met, a large part of our focus was on the 85th session of the Texas Legislature. It was a busy one. It was arguably the busiest that TDLR has ever had. The State House and Senate convened in January and met through Memorial Day, and last month they came back for a special session that should last till next week. So during the regular session, there were more than 6,500 bills, total bills that were filed, and of those bills, TDLR tracked a total of 341, and the breakdown of those includes 130 that were directly related to current TDLR programs, 20 that dealt with new or transfer programs, and 191 bills that, if enacted, would have affected agency operations. But the folks at TDLR worked really hard, and as a team, providing, analyzing and monitoring the bills and providing feedback and research testimony. We attended 65 hearings before 20 different House and Senate committees. During the past session, 2 bills affecting this program were passed and signed into law by the governor. I'll give you a brief summary of each, and you'll hear more from the folks presenting item F on the agenda. One bill affecting this program was House Bill 1886 by Representative Rick Miller and Senator Carlos Uriste. That affects dyslexia screening and testing, the employment of dyslexia specialists by regional education service centers, and the development by the Texas Education Agency of a list of training opportunities for educators regarding dyslexia. The other bill of note was House Bill 4007 by Representative John Kemple and Senator Judah Zaffarini, and that bill removes barriers, redundancies, impediments for the licensing of the 13 health-related occupations that were transferred to TDLR from the Department of State Health Services, including this program. We are now in the middle of our bill implementation period, which means our staff is busy preparing to implement the bills that were passed, and that includes developing rules, communicating to stakeholders, appointing and prepping advisory boards, hiring additional staff, and dealing with education, exams, IT programs, and more details. You'll see a full review of our legislative program on our website if you go to tdlr.texas.gov and click on the Capitol picture. You'll get to the page and they will be presented by program. And one other thing I wanted to again promote our social media. We are on Facebook and Twitter, and we have a special Twitter account for health programs that you might want to follow to keep up with TDLR news and events. But I want to get back to our website for just a minute. At the last meeting, I shared with you some traffic numbers from last year, and I want to update you over the last 7 months. The Dyslexia Therapist website had about 6,200 page views, and that's an average of about 884 per month. Also, this year, this number's gone down a bit, but 38% of those accessing the website are doing so through a mobile device compared to using a personal computer. The top five reasons for visiting the Dyslexia Therapist website. Number 1, licensing related tasks. Number 2, information on laws and rules, followed by FAQs, exams and continuing education information, and advisory committee meetings information. Have any questions? I'd be glad to try to answer for you.
Anybody have any questions?
Thank you.
Okay, thank you. Okay, we will hear from the Compliance Division.
Hi, I'm Yvonne Feinleib with Compliance. You have the report in your packet, so I'd just like to highlight a couple of things. We're working on the Phase 2 transfers, additional programs coming over from the Department of State Health Services, so that's our priority. But if you hear of anything, if you have any issues you'd like to bring to us, we do have teams in place that can work on improvements for ongoing issues with Phase 1. So we do want to hear from you if anything comes up. Right now, we're not hearing a lot in terms of dyslexia issues or challenges in terms of the implementation of the program. It's running pretty smoothly. We have started presenting trainings for the customer service staff, the folks who answer the phones and the email, and the licensing staff together. We do 2 sessions once a month where we highlight specific topics. We haven't had a specific topic on dyslexia yet because we haven't had a lot of calls and concerns where staff didn't know how to answer the question. The licensing rules are fairly straightforward, but if there's a topic you think might be valuable, please feel free to suggest something. We are going to focus in the next few months on the new programs that are coming to TDLR, so the staff is trained and comfortable and ready to respond to questions about those programs in addition to the ones that are already here. And then we did go to the Alta conference. And we are available if there are any kinds of regional meetings where our presence would be helpful. Any questions?
At the Alta conference, was that in Dallas?
Richardson?
In Richardson, and did you have people that?
Yes, we had people come up and ask us questions. Mary Hoffman and I went.
Good, great.
Yeah,
Thank you for going.
sure, it's
Okay.
nice.
Okay, anybody have any questions?
Thank you.
Okay, thanks, Yvonne. Okay, next, Education and Examination Division.
Good morning, Madam Chair, advisory
Morning.
members. My name is Jerry Gonzalez, and I'm with the Education and Examination Division. Since your last meeting, there's really not a lot of updates that we have for the dyslexia program right now. We've been working, as Yvonne said also, we've been working on Phase 2 programs that are about to start, coming over November the 1st. And so getting everything ready, hopefully have a smooth transition as we did with Phase 1 programs, and getting everybody on the same page and getting all our forms and documents together. Also, we have, with the new passing of the legislation that did pass, we have, our division has 8 different, or is on 8 different bill implementation teams. So we're working hard to get all the new changes that came into all the programs and all those programs that it affected. Other than that, we've been, busy trying to get ready for Phase 2. If there's anything else or anything I can answer for you, I'd be more than happy to.
Any questions? Okay.
Thank you.
Thank you, Jerry. Clipping right along to Enforcement Division.
Good morning. My name is John Medlock. I'm a prosecutor with the Enforcement Division. Typically in this presentation, I will put forth cases that have come to some sort of resolution, kind of giving you a brief summary of what happened in that case, either an agreed order, a default order, or a commission order. We don't currently have any, but I can quickly walk you through kind of the life cycle of one of these types of cases. Essentially, if a complaint comes in, it goes through our intake division, then it goes into our investigators, and then eventually gets passed on to me. I basically have about multiple different choices. I can either take a look at the case and say that there is no evidence of a violation, can close it that way. Maybe there was a violation, but maybe it was a small violation. We can close it with a warning if there was some kind of remedial action or something that wasn't, they corrected an issue. If we go forth, we would, with a violation, we issue what we call a notice of alleged violation letter. That will set forth out what the violation is and what the penalty amount for that said violation is. The respondent at that point in time will have a couple of different options available to them. They can pay the set penalty and come into compliance that way. They can ask for a hearing, or they can do nothing. If they do nothing, we'll send out additional letters saying, by the way, there's this letter out there, you need to respond to it, please. If they don't respond to those, then the due process window has passed, and we issue a default order, essentially basically saying that you are now in violation of this. The executive director has deemed that you owe whatever the penalty amount is. That's kind of the one order. So that would be one type of case that I would present before you. If they decide to go ahead and pay the payment, we'll sign an agreed orders depending on whatever the terms are. There may be some additional education, a fine, there may be even a license suspension or revocation depending on how severe the violation is. That's kind of on the bad end of the scale. But that's called an agreed order, and again, that would be a kind of a case that I'd go forth with you guys. The other kind of case is if they ask for a hearing is the longest process that we have. If they ask for a hearing, we go before what the State Office of Administrative Hearings. We'll have a hearing before an administrative law judge. I'll present my side. The respondent has every opportunity to present their evidence and witnesses. The ALJ has about 60 days to draft what they call a proposal for decision. It's basically a recommendation on what the judge finds that the evidence was and is, and what violation does or does not seem appropriate. After that PFD is issued, it will go then before the Commission of Licensing and Regulation. We again present essentially kind of a Reader's Digest version of what happened at that trial, and then the Commission on that day will vote, to either adopt the PFD or amend the PFD however they see fit. And that's kind of the life cycle of the cases. And typically that's what I will be presenting, kind of like the little Reader's Digest. We had an agreed order in this case, this is what the violation was and amount, default, commission orders type stuff. We don't currently have any cases that have been opened yet since the program's come over to us. But as you can see in the information you have before you, is you'll see the statistics that we have of cases that have been opened, cases that have been resolved, agreed orders, the amount of penalties we have assessed and collected throughout the year. As you can see, as TDLR over all of our programs, we've opened over 10,500 cases just this fiscal year, and our fiscal year runs from September to August, so we're almost at the end of it. But this is pretty typical for the amount of cases that we see through this point in time in the year. Also, one thing we'll talk about is something I'll talk about right now is current projects and different outreaches that the Enforcement Division has currently. You will actually talk about this a little bit later today, but on May 17th, we had an enforcement work group to develop the criminal conviction guidelines. Now, Ken Sharp, another prosecutor with our office, will talk about this with you and kind of walk through this further with you. But basically, the criminal conviction guidelines are for people who want to enter into this profession and seek a license. They have to answer criminal history questions, but there are certain guideline crimes, as we call them, that may bar their entry to this profession, or if while they hold the license, they may be subject to having their license revoked because they've committed one of these crimes. But like I said, he'll go over that with you more and further. And so, but on May 17th, that work group did meet, and he will be presenting that for your approval today. If you have any questions, I'll feel free to answer them.
I just have one quick question. When you were talking about if there is a hearing,
Mm-hmm.
that the judge has about 60 days
Yeah,
to make a decision. Does
right.
it usually last that long?
It depends on the type of case. I've had cases where they take all 60 days. I recently had a case where I got the PFD back in about a week. So it depends on kind of the length of the hearing, the issues that are involved, and how complicated it is, frankly. But they most times they do take up to the 60 days because they don't just hear our cases, they hear every state agency's cases, so they hear a whole multitude, so they've got a lot of stuff on their docket as well.
Okay, good. All right. Any questions, y'all?
Thank you.
Thank you. All right. Next up, we will have the licensing division.
Good morning, members. Leonard Rivas with the Licensing Division. Just to give you an update of what the Licensing Division is doing. We're also heavily involved in the Phase 2 programs coming from DSHS on November 1st. We're also heavily involved with the Podiatry Board transferring to the TDLR on September 1st. So we're heavily involved doing that, learning their processes, going over and meeting with the Podiatry Board staff to learn their application process and their renewal process. So they'll be here in less than 3 weeks. I provided you with a copy of the licensing report for the dyslexia therapists and practitioners. We typically don't see issues with the applications. We get very few applications for your profession, and there are very few issues with that. I can go over the report with you, and then if you have any questions, I'll be glad to answer any questions. The first section is for dyslexia practitioners. So the first quarter entails October through November. The second quarter is December through February, and the third quarter is March through May. The total population for dyslexia practitioners are at the bottom of your handout. And then for dyslexia therapists, it would be the same thing, October through November, first quarter, December through February, second quarter, and then third quarter, May through March. And then the population is at the bottom as well, 834 for the therapist. Sure. The first quarter is going to be normally September through November, but because we didn't transfer till October, it's October through November. And then the second quarter is December through February. And then the third quarter is March through May. And I'll be glad to answer any questions if you have any.
Latricia Nigos, are the license renewals sent out all at the same time? Does everybody's license renew like the end of the calendar year, or
No.
are they?
They're staggered.
They're staggered.
Mhm.
Okay. Any other questions? Okay.
All right, thank you.
Leonard. All right, we will move to item F on the agenda, please. And this is to discuss the 85th legislative session bills.
Laura Pefferly, General Counsel's Office. Two bills to note, which I'm sure you've heard of HB 4007 already. This one made some minor changes to the statutory wording, and we'd already accounted for that in the rules, the initial rules that were adopted. So I don't see any reason to do a rulemaking on the basis of 4007. Now on HB 1886, which is in your materials, you're probably aware of this one. It creates a position for a licensed dyslexia therapist in each of the 20 regional education centers in Texas. The requirement for screening or testing for dyslexia in kindergarten and first grade is in there, and also for TEA to develop a list basically of continuing education training for teachers that focuses on the identifying and teaching kids with dyslexia. That one, I'm not real clear on whether every teacher who's teaching dyslexia is licensed by TDLR. I suspect they aren't. And so that continuing education that they're supposed to develop and have available for them is probably not a continuing education that is going to be suitable for licensees to take. It seems to be geared for teachers. It looks to me like there may be a little bit of overlap on that, on teachers teaching material that's appropriate for students with dyslexia. It may be something you want to look at. I don't really see a need for rulemaking based on this bill. Now, TEA is supposed to create a program, and you may want to have some input into what they're doing and how they're developing this training, that sort of thing, but I don't know that it's going to affect the regulation of our licensees. If you feel differently and you feel like we need to do some kind of change in the rules, we can do that. If there are issues with the continuing education that, like, you feel like there may be something we need to have in our rules, or even maybe a frequently asked question or something on our site, there are different ways to address it. If you see any kind of issue there with a conflict or an overlap, or you feel like they're expanding the role of a teacher too much into dyslexia therapy or something. So I'm not the expert on the subject matter, you are. So if you see something there that you feel like we really need to address that is going to be an issue for the licensees, you can certainly bring that to our attention. But from my perspective looking at it, I don't really see any changes to our rules that are necessary. So this may be something you want to look at more or discuss. If there is a change you think we should make, you may want to wait until you see what the TEA does, give them some input, maybe some comment about where they may or may not want to go on their rules and their education, continuing education. So other than that, there really isn't any other legislative change of note that would affect the rules for dyslexia that I can see. So if you feel like you want to talk about this bill further, you could, certainly add that to the agenda for next time if you want to, look at it more and discuss that further.
Do you have any questions?
Laura, you said the TEA was going to create the program, correct?
They are supposed to.
Is it considered like a screener? Is there a deadline when they have to create?
I don't believe there's the changes are effective with the 2018 school year, and they have to hire these therapists for each of those regional centers, and they may or may not already have them. I'm not sure if all of them have one. They don't. You don't think they have one. So it may not be that they need to develop any kind of program to just hire these people, but for the training, creating the list of this continuing education training, and for the requirements for the screening and testing, I'm not sure how much they're gonna have to tweak their rules, and how much they may need to develop or expand a program. It's just not something I'm real familiar with in practice, how they're doing this or what they're doing right now. But I do know it says it's for the next school year, the upcoming school year.
Which is around the corner.
Robin Kauser, from what I understand from meeting with TEA, especially with the special session being called, these things have not really been addressed yet. And what I did gather from that is much of this falls in the lap of the local school districts. And so there's not going to be a standard screening that is going to be blessed by TEA as much as each individual district is going to be required to come up with that screening. And I feel like after the session is over, then maybe there'll be a little bit more detail looked into as far as how they're going to implement this, because yes, it is right around the corner. And at this point, I don't know that there's any plan yet on checking into the accountability and how TEA is planning on making sure that each school district is in compliance with 1886. So maybe that is something that we want to revisit for the agenda for the next meeting. Anybody else have anything?
Latricia Nigos, I would be interested to request from TEA that, because I'm not sure when we're going to meet again, but it may be that they start that implementation before we meet again. And it would be nice to have some input from, since it does pertain to licensing, because they're going to require a licensed practitioner or dyslexia therapist, that we have some input in that, since it does, it won't influence us, but we could influence them.
Mm-hmm. So how would that request be done?
I'm not sure, I'm reaching for microphones. You're correct. Mary Winston, TDLR. House Bill 1886 is pretty general in the implementation. There are requirements, but there are general requirements, laws relating to dyslexia screening and testing in public schools, upon enrollment in kindergarten, employment of the dyslexia specialists by regional education service centers, and development of a list of training opportunities for educators regarding dyslexia, as well as transition planning for students enrolled in special education. So saying that there's a development of a list, it's pretty broad. That's kind of hands-off, and for what Ms. Kauser is saying, district by district, they're looking for a list, and the districts will be who implements that. And all of this is beyond the TDLR scope, but you all are a board, and if there's input that you want to provide, let us do some more research into this bill And we can reach out to you individually. If we need to have another meeting, we will. We don't have, once we get past our criminal conviction guidelines that we're going to discuss, which is an action item that you have to take so we can move it forward to the commission. We don't have anything on our plates internally for you guys, but this is something we want to put on the next meeting, and even maybe before the next meeting. Give us a chance to research so we can figure out how we can, and if we can, provide information on that for TEA.
That sounds perfect. Yep. Okay. Thank you, Mary. Anything else on this issue? Okay. Then we will move to item G. He's needing water. This is important stuff.
This is not Starbucks.
No matter how hard you want it to be, it's not.
Well, I needed some water back there. I think I'm allergic to having people introduce me in like a movie trailer. But I appreciate it, John. Well, good morning. My name is Ken Sharp. I'm an enforcement prosecutor for the Enforcement Division, as John said earlier when he was so graciously introduced me, and I appreciate that. And I'm here to present to you the proposed criminal conviction guidelines that were developed for the dyslexia therapists and practitioners. As he said, we had a work group that met or got together, I guess. Part of it was phone conference. Board members Nigos and Masick who helped us out with that, or I guess maybe did the lion's share of the work. I don't know how you would more accurately characterize that, but we certainly met and we went over these things, and we formulated the draft that we're presenting to the board this morning. And before we get into it, though, I'd like to give you a little bit of a background. Excuse me. I'm going to talk to you a little bit about the origin of the criminal conviction guidelines, why we have them, how they benefit the public, the industry, or your profession, and licensees as well. That's something that's especially important, and we'll get into that. And then we'll examine these and proposed guidelines and discuss them to the extent necessary. And at the end, I'm going to ask that you adopt these and recommend these to the Commission of Licensing and Regulation for adoption for this particular occupation. Okay, well, first let's talk briefly about the criminal conviction guidelines, where they came from. The legislature created regulatory agencies, as everybody knows, but they did it for several different purposes. And chief among those is consumer protection and public safety. One way that we try to achieve that goal is by limiting licensing to people who can be trusted to honor those principles of public safety and consumer protection. People who will honor the trust that's placed in them by being licensed to be in this profession. So we're especially wary of persons who have a history of criminal behavior. Now, we at TDLR, we carefully screen each application for criminal convictions that should probably compel us to deny an application or maybe revoke a license, so, for example, if it's a renewal application. But the question becomes, how do we know which of these convictions should disqualify somebody and which of them are really not going to make any difference? Consider for a minute, if you will, we regulate cosmetologists here. So consider for a minute, if you will, a person who applies for a cosmetology license and has a criminal conviction for illegal oyster harvesting. Probably not going to make much difference, is it? And so, you know, that's something that we want to look at that and know, yeah, it's a criminal conviction, all right, but is it really something we want to disqualify that person for? You know, no, because it really doesn't have anything to do with that occupation. The legislature recognized this also, and by statute, the legislature said to each licensing agency, you compile a list of those crimes that are directly related to the occupations that you administer. You compile that list and you say these are the crimes where people should probably be disqualified from having a license. And oh, by the way, you add on there the reasons why those crimes should be considered as disqualifying. So we have the criminal conviction guidelines. That's where that comes from. And it's very simply a list of crimes which may affect a person's eligibility to hold an occupational license, and then, of course, the reasons why that effect may occur. And we often refer to these in a kind of a shorthand reference as guideline crimes or the guidelines and so forth. Before we get too far along, though, I want to talk to you about a few other reasons, legal reasons, why the department can or should deny an application or revoke a license that's already existing. We get some basic but pretty comprehensive guidance from Chapter 53 of the Occupations Code, and in specifically Section 53.021A. That's got a list of 4 categories of crimes that authorize the department to deny a license application or revoke a license. Like I said, there's 4 parts. We're going to skip the first one now, but let me talk to you about the 2, 3, and 4, and then we'll come back to number 1. The second one on that list, these are non-guideline crimes. These are not ones that are directly related to this occupation, but they're ones that occurred within 5 years prior to the date of the application. These could be important because they could show a continuing tendency to disregard the law and to commit criminal acts. And so we have that flexibility to use those even though they're not guideline crimes. The next one on the list, these are crimes that are listed in a provision of the Texas Code of Criminal Procedure that limits the availability of community supervision or probation, if you will, for certain crimes. And these are particularly bad ones, like murder and aggravated robbery, aggravated sexual offenses, indecency with a child, things like that, really, really bad crimes. They limit the probation and that community supervision because they are so bad, and we want to limit licensure for people who commit those types of crimes as well. Now, I'll tell you also, these are often guideline crimes. When we look at the various occupations, we'll see a lot of those in there, or at least those categories of those crimes in there. So there may be some overlap. But even if they are not listed as guideline crimes, we still have, again, that flexibility that we can use those as a basis for denial or revocation of a license if we need to. The 4th one in that list is the sexually violent offenses. This is in another part of the Code of Criminal Procedure, and it's in the part that has to do with the registration, sexual offender registration. The sexually violent offenses, again, these are particularly bad crimes, but they're ones that have a sexual component to them, like indecency with a child, aggravated sexual assault, even burglary with the intent to commit a sexual offense. We have that flexibility. We can use those if we need to, if they're not in our guidelines. So these are 3 independent bases for the revocation or denial of an application, even if they're not in the guidelines. They're laws of general application, but they're broad, and we do find them useful and necessary from time to time. There is another standard for the denial of an application or revocation of a license, particularly with dyslexia therapists and practitioners, and that's in the statutes that pertain to this profession. The standard there is whether a person has been convicted of a misdemeanor involving moral turpitude or a felony. And it's kind of vague, it's pretty broad, and it leaves a lot to interpretation, and particularly when it comes to what constitutes a crime of moral turpitude. The courts have addressed that in part. There's no definitive statute for it. There are some regulations that say a crime of moral turpitude is this, but another agency might say, well, yeah, but ours is this. And so there's really no guidance with respect to what a crime of moral turpitude is. We found that we're on more solid footing with Chapter 53. It gives us that, along with our criminal conviction guidelines, that gives us more precision. It's a better defined and a more uniform standard that we can refer to when we're making these decisions. Excuse me. Okay, but let's go back now to the first reason for the license revocations or denials, the one that we skipped when we first began to talk about Section 53.021A. These are the crimes that are directly related to occupations. Remember that list that's required by the legislature? The same thing. You know, agencies, you make up a list. If that's directly related to your occupation, then those are the things you probably shouldn't license people for. Well, that's kind of what this is too. That list of crimes that are convictions that may affect a person's eligibility for a license. That's the essential nature of 53.021A1. that first category. And that pretty well completes our list under that provision. So to summarize, we can deny an application or revoke an existing license for direct crimes that are directly related to the occupation, crimes that were committed within 5 years prior to the application date, crimes that are particularly bad, those like murder and aggravated assault and so forth, and the sexually violent offenses, aggravated assault, indecency with a child, compelling child pornography, and those kind of things. Do you have any questions on this stuff so far? Okay, if you do, jump in and interrupt me, because I'm used to being interrupted. I appear for judges, and they do that all the time, and so that's fine. Before we get into the specifics of the proposed guidelines that we have here, let's talk for just a minute about the mechanics of our process here at TDLR. I think you might find that helpful too. We carefully screen each applicant for criminal convictions. We especially look for those convictions that are listed in the criminal conviction guidelines that we have, but we would look for any that would render a person ineligible or render it inappropriate to issue that person a license for those other reasons, under Chapter 53 and any other statutes that might authorize the denial. And you notice that I said authorize and not require, because we don't have any statutes that require, not in this setting. I mean, there are some occupations where they say you may not have a license if, but not here, not for this profession and not for most of them. The statutes authorize the denial or revocation of a license, and of course that requires us to determine, well, should we? There's an old saying that says, good judgment comes from experience, and a lot of experience comes from bad judgment. And I can attest to that. I mean, people make mistakes. We're not perfect. I'm one of those. I got a speeding ticket in 1995, and they didn't take my driver's license away from me. I don't know, maybe they should have, but they didn't. They still let me drive, but they just don't want me to speed anymore. Well, the same holds true for these occupational licenses. If we grant a person a license, it's probably because we feel pretty safe that they're not going to commit those kind of things again, or if they do, it's not something that we would want to revoke the license for. So we look at all of these things to determine what makes a person ineligible for a license. And some of the factors that we look at are, how old was the person when the person committed the crime? Like me, in 1995, I was about 18, I think. How old was that person at the time? How much time has gone by since then? What type of conduct or activity has that person been involved in since then? Has this person shown signs of rehabilitation? All of these things, and there are a few more as well, but we look at all of these things to determine whether we should revoke a license, which is what an administrative law judge is going to do, as well as the commission, if the decision comes to that point. In practice, let me give you an example. Suppose you have a license applicant for an electrician's license. Had a recent DWI. That's not really going to affect what an electrician does, unless he drives an electrician's truck. But if he's a passenger or whatever, I mean, it doesn't really affect hooking up the wires and things like that. So it's not a guideline crime for electricians. It might have happened within the past 5 years, but if that's the only thing out there, is that something that we really want to deny somebody a license for? I don't think so. On the other hand, what about a tow truck operator? DWI all of a sudden becomes pretty significant, and it is a guideline crime. It is listed in the guidelines for tow truck operators. So we would consider that very carefully. But now again, suppose that happened 10, 15 years ago, and nothing else has happened since. No other criminal activity since that time. Case by case, we look at these and we make a decision on a case-by-case basis, because in that case where a person is shown he's not going to do that anymore, we're probably okay giving that person a license. One more example. Air conditioning and refrigeration technicians. The guideline for that particular occupation says crimes against property, like theft and burglary. So if you're going to be a thief, we're not going to let you go into people's houses and fix their air conditioners. But suppose you have a young fella, he's 30 years old, he applies for a license. He had a conviction for shoplifting when he was 19, 11 years ago. Nothing since. Probably not going to deny him a license either. Looks like he's going to be a pretty safe bet. So this is how we work these things. We look at them, and even though somebody may have been convicted of something, that might not necessarily disqualify the person. The same would hold true for dyslexia therapists and practitioners. Even though a person maybe was convicted for something that, if it was last week, would disqualify them from that crime. If it was 15 years ago, then is probably not going to today. There's one more factor that is used in these determinations, and that's something that's in our statutes. Honesty, trustworthiness, and integrity. We typically see this when people apply for a license or apply to renew a license. There's a question on those applications that says, have you ever been convicted of or placed on deferred adjudication for a criminal offense other than a speeding ticket? People will say no. No, I'm a clean record. I'm good to go. And we look at their criminal record because we look at everybody's criminal record when they come in here. And we find out they've got a bunch of stuff on there, and there's a lot of stuff that would disqualify them. And a lot of times that's why they put no, is because they don't want us to find out about that, and they think it's the only way we're going to find out about it is if they tell us. But that's not the case. That's an indication that we can't trust this person, that this person's not very honest, that there's a lack of integrity here. Truth is, we never use a lack of honesty, trustworthiness, and integrity by itself because we don't have to. That's always a manifestation that, of the other things that are underlying this. The person's got a criminal record but says, no, I don't have one. Well, we look at the criminal record. We use all of these things together, mind you. It's an overall consideration. So we would not use that by itself just to disqualify a person because I don't think we would ever have any reason to. Okay, so we look at the guidelines. We look at Chapter 53 of the Occupations Code. We consider the person's honesty, integrity, and trustworthiness. We look at all of those factors that I spoke of, and then we determine whether a person should have a license, and that's where we make the decision. We put it all together and then make that decision. Hopefully that gives you an idea of how we use those criminal conviction guidelines and the other things that we have available when we screen applicants who have a criminal history to determine whether they should be licensed. I mentioned it when we started, the guidelines are useful to TDLR, but they're also useful to the license applicants and to licensees, people who currently hold a license. They're published in the Texas Register. They're published on our website. They're publicly available, so anybody who thinks they want to apply for a license, or even a license holder who says that, yeah, I got convicted of this, I wonder if it's going to affect my license, they can look at these guidelines and they can make that determination on their own, or at least they can get an idea of it. So, for example, if you have someone just out of prison for fraud and now applies for a license in your occupation, our proposed guidelines, they include crimes that involve fraud or deceptive trade practices. So would that person be eligible? You probably not. And I just want to reiterate, that may not be forever. This person may go for 10, 15 years, become a member of the Chamber of Commerce, who knows what all, and may become an upstanding citizen, and then at that time apply for a license, and then we would probably look back and say, based on what this person has done since then, it's all been good, okay, that person is eligible for a license. There's another useful way, a good use for the criminal conviction guidelines. Applicants can ask us beforehand, before they ever apply for a license, they can say, I've got this criminal record. I don't know if I'm going to be eligible. Can you tell me before I even bother to go through all of this stuff? Go through the training, go through the schooling, all this? We can give them a kind of an advance notice on whether they'll be eligible. It's called a criminal history evaluation letter. They'll tell us. They're supposed to tell us what they've been convicted of or what they've been placed on deferred adjudication for. We look at their criminal history as we can find it, and we put that all together, and we make a preliminary determination of eligibility. Then we'll send them a letter, and we'll tell them whether they're eligible or not, and why. Most of the time, if we say they're not eligible, they'll say, okay, well, I'm going to do something else. Most of the time, if we say they are eligible, they'll go ahead and apply for the license. There's one caveat to this. If they do apply for the license, and we find out there's something they didn't tell us about, or that we weren't able to find out about right at the time we did that initial determination, we're not bound by that. We can say, well, I know we said you were, or probably were, but no, you're not, and here's the reason why, and we'll tell them at that time as well. So it provides a pretty accurate predetermination of eligibility, and that's useful to, like I say, the vast majority of the people who use that particular procedure. Okay. Any questions before we go on to the guidelines?
I want to ask something. I'm Betty Daniels. Every time, even when an applicant comes and wants the license for the first time, they're going to have that history report or the criminal background done. This happens even with the renewal. It's always constant anytime somebody applies for a licensure here.
Yes, it is.
Okay.
Excuse me. Well, I have to say that when we worked on these proposed guidelines, we really appreciated the participation of the board members because we got a lot of valuable insight into your occupation, into the type of clients you serve and the type of contacts you have with them, the contexts in which you provide those services and so forth. So that was very helpful to us. And we also appreciate the very thoughtful and serious consideration that the work group gave to the types of crimes that would constitute a basis for the denial of an application or revocation of a license. And that consideration and thought that went into this shows up in these proposed guidelines. With respect to these guidelines, you'll first notice that it deals with types of crimes, not specific crimes. It doesn't list robbery, theft, murder, not types of crimes, categories. And the reason for that is because there is so much variation between different courts and different states as to how they characterize crimes. Whereas one state might characterize a crime as rape, another one might say sexual assault, and another one might say something different. Even the different courts in our state, the district courts, the county courts, the different counties, municipal courts, they have different names for things. The federal courts, they've got a whole other scheme out there, and they use different names for things that we don't use. So we use these categories that we can find, or that we can characterize these crimes in these categories. We'll use examples, like the crimes against property, such as theft and burglary. Crimes against the person, such as assault, homicide, kidnapping. That helps us to keep, or to prevent things from slipping through the cracks and we accidentally give a license to somebody who shouldn't have had it just because of a characterization of a crime that we didn't anticipate. So it lists the types of crimes and it also lists the reasons that these particular crimes relate to the occupation, just like the legislature told us to do. And we'll look at a few of these right quick, and I won't read them to you, but we'll take a look at them and then we'll talk about these and see if you have any questions. I told you a minute ago about the crimes against the person, homicide, kidnapping, assault. That's not an exhaustive list. It can be something else. It could even be robbery, for example, because robbery is a crime against a person. It involves the element of assault, just as it's also a crime against property because it involves an element of theft. So that, even though it's not listed here, it would fall under that category. We don't want people doing that kind of stuff. We don't want people, practitioners hurting anybody, or licensees. We don't want to hurt anybody. The prohibited sexual conduct is there because typically people, well, I don't know about typically, but often people who are in the position of a therapist or a counselor or a practitioner or something like that, if only perceived, they're holding a position of authority, of trust over the client. And someone who would take advantage of someone else for their own sexual gratification has no business having that kind of position. We've got, for the same reason, the crimes involving the elderly or children or disabled persons as victims. For that same reason, again, you know, these folks are in a position of trust, and we have to be able to trust them, that they're going to do right by all the clients. We don't want thieves. We don't want anybody saying you shouldn't be licensed because you're a thief. We just don't want to license them to begin with. The same with the fraud or deceptive trade practices. This could mean insurance. It could mean overbilling people. It could mean a number of different things. But we just don't want to have our licensees, and I know you don't want to have them in your profession who are licensed, who are involved in this kind of conduct. As I said before, those people who perceive practitioners and therapists as having that position of authority, that position of knowledge, that position of, in a sense, superiority. If a person in that position says, well, you know, I can help you. I can provide you with something that will help you more than just this therapy. Not only the clients, but also the family members. And, you know, you need to calm down because this person is causing you so much problems and all this. I got something that can help you. Hopefully that would never happen. We'll do everything we can to ensure that it never happens. And that's why this category of involving the possession or delivery of drugs and so forth is in there. And finally, we have the crimes that involve being under the influence of alcohol or drugs. People are not at their best when they're impaired by substance abuse. And so we certainly don't want people in the profession trying to render these services to the clients when they're impaired, and they're not going to be doing their best, and they're maybe even doing more harm than good. People who are under the influence of substances lose some of their inhibitions and lose their good judgment, and they could do other things. They could become involved in confrontations, even violence from time to time, as you may have heard from news reports and so forth. So we don't want people to be in this position when they're under the influence of alcohol or drugs, and that's the reason that we have this one. I know you have those, and you've probably looked at them probably more than once, but if you do have any questions, I'll be glad to answer these, or answer any questions that I can.
Latricia Nigos, would you explain to the board where the framework came from for these guidelines?
Do you mean for the guidelines in general, or these particularly?
These in particular.
We had looked at other occupations that were similar, medical profession type occupations, and we said, you know, they're doing kind of the same thing. For example, the hearing fitters and dispensers. They kind of do the same thing, they don't do the same thing substantively, but they're kind of in the same position because they meet with people. They're on a one-on-one basis frequently. They have clients. They're in that position of superiority and trust with respect to their clients, or at least clients can readily perceive that. So that and some others as well. We looked at those and we said, you know, this is comparable. We want to protect these people just as much as we do the others. And so that's how we kind of came up with these as a starting point. And then when we got to the work group, we hashed it over and we made a few tweaks here and there. And I don't remember if we omitted or added any, but right offhand. But it was a very productive session, and that's how we came up with these.
Thank you.
Well, I appreciate your attention and your consideration of all of this information. I know it's a lot, but these criminal conviction guidelines are important. They're required by the law, and they're important because they help us to, well, police the profession and make sure that we only have qualified and good people out there doing this, which I know is what the industry wants. We appreciate it, and we would ask that you recommend to the Commission of Licensing and Regulation that they adopt these regulations. Thank you.
Thank you. Okay, so I think that we need a motion to adopt. Do I have a motion? You can motion. Okay, do we have a second?
Second.
Okay. All right, then I think we move to adopt these recommended guidelines to protect our licensure.
Did we vote?
And we vote?
We, Mary Winston, we had a motion, we seconded the motion, we just need to vote on the motion.
All in favor, say aye.
Aye.
Any nays? Okay, the ayes carry it. Thank you all for that. Okay, so I think we are on to H on our agenda, and that is recommendations for agenda items for the next committee meeting.
Mary Winston again, I think we identified one, Madam Chair, an update on House Bill 1886. So we'll put that in there?
Yep. Also, I believe there may be a couple of things that are outstanding with the special session that might affect dyslexia, so if we can at least not revisit, but just put that on the agenda if there are if anything's passed.
We can definitely do that as well.
Okay. Is there anything else that anybody wants to make sure that we put on for the next meeting? Nope. Okay.
Latricia Nigos, do we have any work groups that are continuing that maybe we need an update on work groups that have already been established?
That's good. We have a couple of work groups that have not met yet. I think that this, the guidelines, that was decided that that was going to be the most important work group, most pressing work group. There are Education and Examination Division that have not met yet. Mary, will we be contacted as members of those work groups?
Yes, staff will contact if there's a need to meet. I'm looking at the education and examination statistics and trends. And of course, this is a national exam, so they don't have statistics on examination. But I just saw the director walk in, and Mr. Bizzarro will make sure that if there's a need to meet, his team will contact
Okay,
the members.
great. And the same thing for the licensing division work
Yes.
group?
Yes.
Okay.
So we could add that as updates from those work groups.
Okay, yes, to put on the agenda.
Yes.
And then, I believe that there was a fourth possible work group that at the last meeting we decided that we were going to decide if there needed to be a work group for, what was it?
Standard
For standard of care.
Yeah, thanks Yvonne, but they can't hear you out there, so, for the standard of care work group,
Mhm.
okay.
So what do we think about that? Is there a need for that work group? Because I don't think we even assigned members.
We did not. I know we got out of the way first, the guidelines, and that if you would like to sort of establish that now, and we can look into, if we need to meet in compliance. Will, I'm getting a nod, no. Yvonne's coming up now.
Yvonne Feinleib with Compliance. So generally, the standard of care work group will meet either if we need to deal with a particular standard for the profession in the rules, either to establish guidelines in rule that are enforceable, or to prohibit particular problems that are going on, or if something changes, either in state law or in national standards where something in the rules is obsolete and we have to update. And really, most of the standards for this profession are out in the professional practice. They're not encapsulated in our rules. And we're not receiving complaints that people are doing really unwise and foolish and dangerous and ineffective things, and we really need to write rules that will make sure they are practicing properly. People seem to have been properly trained, and their continuing education is keeping them up to date. So I don't think you need one right
Okay.
now based on what I can see, but you always have the freedom to establish one in future if one is needed. Does that make
Okay.
sense? I don't want
Yes.
to waste your time getting together and looking at our rules and saying,
Here they are.
yes,
Okay.
okay?
All right, well, good. Thanks,
you.
Yvonne.
That's
Thank
great
you.
news, thank you.
Okay. So we have the update on 1886 and update on special sessions. Are there any other items for the next agenda?
Aside from the work groups from E&E, Education Examination, and Licensing, any updates from those work groups? We're looking at, we might as well kind of jump in if it's okay with you, Ms. Cowser, the date and time of the next meeting. And we're looking at setting that several months out.
Okay.
This will give us time to see the end of the special session, how 1886 could impact the profession. If there's a need for the work groups to meet, we can get those reports. And then we have a slew of new programs coming on board,
Yeah.
and that will actually help staff as well.
Mhm.
So we have our timeline for our bill implementation for the 85th session, and in your section, the time to meet for the next advisory board meeting is in the first week of April. And we're looking at April 3rd, April 5th. This kind of gets you first dibs on your rotation of this set. You all have handled your business that was necessary so far. We do have some more issues that we're gonna, investigate and research internally and get back with you. But you don't have any more business right now that we need to drag you back in to visit, unless you just wanna come say hi, and that doesn't have to be a public meeting.
Okay, well, do you all have a preference on April 3rd or April 5th? Mary, do you know what days those are?
The 3rd is a Tuesday,
This is Thursday.
Does that
and
sound
the
good?
5th is Thursday.
Tuesday?
Tuesday the
Tuesday.
3rd?
That's fine.
Does that sound good to everybody?
Is 10 a.m. good? Okay. And in the meantime, if there are other issues that come up, we can definitely slot them for the agenda. We just want to make sure that we actually have a little meat to chew on when we visit and have a meeting. And so between now and then, if something in the session comes up, special session, or something in 1886 and the implementation affects you, we'll know and we can discuss it at that time.
Okay. All right, then we will plan on meeting again on April the 3rd at 10 a.m. And if there's nothing else that needs to be discussed on the agenda, it is 11:10, and this meeting is adjourned.